Good day, everybody. My name is Munira Suleiman Binji from the National Collateral Registry of the Central Bank of Nigeria. Today, I'm here to talk about the secure transactions in movable assets. I'm sure many people will be wondering what secure transactions in movable assets means. We'll get to know in a short while. So, this is the outline for our discussion today. We are going to talk about terms associated with secure transactions. We are going to talk about the Secure Transactions in Movable Assets Act of 2017. We are going to talk about what the NCR is and how it is linked with secure transactions in movable assets. We are going to talk about the acceptable collaterals to be used in STME. We are going to talk about the benefits to be derived from using STME. So without wasting much time, let's talk about the terms we will be seeing as we go along. Borrower. Who is a borrower? A borrower is a person to whom credit is extended with an obligation to repay at a future date. Who is a creditor? A creditor is a person who extends a loan to another person and on the back of a security, meaning after accepting a collateral for that loan. Now, who is a grantor? A grantor is the person that has rights or ownership over a movable asset, over the collateral. Now, let's understand that the borrower and the grantor can be one person or two different people. The person that goes to obtain a loan can be the actual owner of the collateral, or he may get the collateral from another person and use it to get loan. So now, what is security agreement? Security agreement is an agreement between the creditor, meaning the lender, and the debtor, that is the borrower or the grantor, that creates a security interest in the collateral. What is security interest? Security interest is a property right in a collateral. It means the person that creates a security interest has a kind of right or lien over the movable asset. It means he can recover the assets, that is the creditor now, can recover the assets from the borrower should the borrower default in repaying the loan. Let's talk about financing statement. Financing statement is an online form obtained from the NCR portal, which the creditor fills and registers on the portal in order to perfect his security interest in the collateral. So, financing statement is a perfection instrument. It is an instrument used to perfect security rights in a collateral. What is perfection? Perfection simply means registration of a security interest on the NCR portal. Now, let's introduce STME properly. The Central Bank of Nigeria introduced the Secure Transactions in Movable Assets reform in 2014 in collaboration with the International Finance Corporation of the World Bank. And this reform was introduced to address information asymmetry that led to market failure. Market failures were characterized by moral hazards, adverse selections, collateral mismatches, weak creditor protection, high collateral ratios. So the SCMA provides lenders with mechanism to establish security interests in movable assets, as well as for registering security interest in pledged collaterals by the borrowers. Well, let's briefly talk about what this information asymmetry really means. So collateral mismatches. What is collateral mismatch? collateral mismatch is a situation whereby we all know that micro, small and medium enterprises hardly ever have any lands or buildings to offer as collaterals. And we also know that the lenders prefer lands and buildings or buildings as collateral. So in accessing loan, the borrowers now find it very difficult to do so because they don't have the required collateral by lenders. What they have are usually small properties that they own to run their businesses, such as sewing machine for the tailors, hair drying machines for the salon owner, laptops for IT person, and so on and so forth. So there's a lot of collateral mismatch, which made it very difficult to access loans for these borrowers. Another thing is weak creditor protection. And I may even say that it goes beyond weak creditor protection and also weak borrower protection. So the SCMA now came about and spelled out the duties and responsibilities of creditors and borrowers so that one will not feel cheated by the other. And then high collateral coverage ratios. This means that in most cases, these borrowers will only need maybe a small amount, maybe 100,000, 200,000 to maybe start up a business or expand their existing business. But the lenders now will require a collateral worth maybe 10 million from them. And the loan they are seeking is only about 500,000 naira. So there was a lot of gap in the collateral demand, which made it difficult for these borrowers to access loans. So this is what the SCMA came to take care of. So in essence, what the SCMA does is to make you comfortably pledge any of your movable assets as collateral to obtain loans from banks and other financial institutions. The SCMA Act of 2017 protects the borrower, the owner, and even the creditor from any kind of indiscretion that may happen or that may occur from any party to the transaction. Now, let's talk about the objectives of the SCMA. The SCMA has 6 main objectives, and we are going to look at them quickly. Number 1 is to enhance financial inclusion. This is by making people that were initially unbanked and bringing them into the formal sector of the financial system, because before you are even advanced a loan from a financial institution, you have to have a bank account. That alone is in promotion of financial inclusion. The second objective is that the SCMA stimulates responsible lending to micro, small, and medium enterprises. Responsible in the sense that before any financial institution or creditor lends to a borrower, they are supposed to conduct a search about the collateral pledged by that borrower on the NCR portal to determine the status of that collateral. That is, to know whether that collateral has already been used to obtain loan in another financial institution. This will make them have an informed decision about the loan they are about to advance to the borrower. That makes them be in a responsible situation and make informed decision about the credits they advance. The third objective is that the SCMA facilitates access to credit using movable assets. We've already talked about this. Borrowers now can tender in and that can pledge their movable assets and get loans easily. The fourth objective is to facilitate perfection of security interest. Perfection, like I earlier said, means registration of a financing statement on the NCR portal. This registration gives you the perfection rights, and this right gives you priority over a collateral. In case another person gave out loan using the same collateral, the person that registers and perfects that collateral first will get priority to recover the loan in the event that the borrower defaults. Another objective is that it facilitates realization of security interest in movable assets. Realization simply means recovery or repossession of the collateral. This means that where the borrower defaults, the SCMA makes it easier for the creditor to recover the collateral from the borrower. We'll look at it when we are talking about judicial means, about the mechanisms for repossession as we go further. We have two mechanisms for repossession. We have the judicial means and non-judicial means. We'll look at it as we go along. Then the final objective of the SCMA is to establish the collateral registry to provide for the operations of the SCMA, and that is what we are doing right now. This is what the NCR does. It implements and operationalizes the provisions of the SCMA Act 2017. Moving on, we'll talk about the NCR and its functions. The NCR is a notice-based registry. It is online, it is automated end-to-end, and it is publicly available. What this means is it is searchable. Anybody can log into our portal and find information they are looking for about a particular collateral. It is automated. It does not have any manual presence to it. Everything is done end-to-end online, and we do not tamper with any information that the creditor imputes as they register their security interest. Everything is done by the creditor, and the NCR does not change or tamper with any information. As the creditor imputes, that is how anybody that searches on the portal will see the information. Also, the NCR is the primary registry for all movable assets in the country. The SCMA Act 2017 requires that all public registry interface with the NCR for easy information sharing. Also, the functions of the NCR are simply to receive, register, store information, and make it available for anybody searching for such information about a movable collateral. Next is security agreement. If you remember earlier, I mentioned that security agreement is a document that is executed between the borrower and the lender, and it is a document that creates a security interest on behalf of the lender on the collateral. So what are the contents of a security agreement? The contents of the security agreement are intention to create security interest. It must identify the parties. It gives details of the loan facility. It describes the collateral in a very adequate way that anybody that sees the collateral will easily identify it. The security interest also contains details of insurance cover about the collateral. It also tells about the extent of the security interest in the movable assets. Also, the security interest must contain the consent given by the grantor now or the borrower that the collateral should be registered by the lender on the NCR portal. It also contains the agreements between the parties that in the event of any civil dispute or misunderstanding, they will submit to the Mediation and Dispute Resolution Panel for resolution before it even escalates, before it possibly maybe goes to court. The Dispute Resolution Panel is the first line first line of recourse for dispute resolution as far as the SCMA is concerned, then the security agreement must also contain the agreed repossession mechanism between the lender and the borrower. The agreed repossession mechanism can either be judicial or non-judicial. Judicial means they have to go to court to enforce recovery, while non-judicial is an agreement between them that should the borrower default, the creditor can easily repossess the collateral without having to go to court, without any hassle. The borrower will just hand over the collateral to the borrower. And we are saying this because the STMA encourages lenders to leave usage of the collateral to the borrowers, because we believe that it is those collaterals that they pledge, their sewing machines, their cars, and other property that they use to generate income that they will repay the loan with. So we encourage lenders to leave the collaterals with the borrower so that they can use it to repay their loans. Now let's introduce STMA properly. The Central Bank of Nigeria introduced the Secure Transactions in Movable Assets Reform in 2014 in collaboration with the International Finance Corporation of the World Bank. And this reform was introduced to address information asymmetry that led to market failure. Market failures were characterized by moral hazards, adverse selections, collateral mismatches, weak creditor protection, high collateral ratios. So the STMA provides lenders with mechanism to establish security interest in movable assets, as well as for registering security interest in pledged collaterals by the borrowers. Well, let's briefly talk about what this information asymmetry really means. So collateral mismatches. What is collateral mismatch? Collateral mismatch is a situation whereby we all know that micro, small and medium enterprises hardly ever have any lands or buildings to offer as collaterals. And we also know that the lenders prefer lands and buildings or buildings as collateral. So in accessing loan, the borrowers now find it very difficult to do so because they don't have the required collateral by lenders. What they have are usually small properties that they own to run their businesses, such as sewing machine for the tailors, hair drying machines for the salon owner, laptops for IT person, and so on and so forth. So there's a lot of collateral mismatch, which made it very difficult to access loans for these borrowers. Another thing is weak creditor protection. And I may even say that it goes beyond weak creditor protection and also weak borrower protection. So the STMA now came about and spelled out the duties and responsibilities of creditors and borrowers so that one will not feel cheated by the other. And then high collateral coverage ratios. This means that in most cases, these borrowers will only need maybe a small amount, maybe 100,000, 200,000 to maybe start up a business or expand their existing business. But the lenders now will require a collateral worth maybe 10 million from them. And the loan they are seeking is only about 500,000 naira. So there was a lot of gap in the collateral demand, which made it difficult for these borrowers to access loans. So this is what the STMA came to take care of.
Good morning, everyone. My name is Mohammed Ali Megari, and I'll be continuing from where my colleague stopped. So I'll be talking about the STMA statistics, we have more than 700 searches conducted on the STMA, and we have over 400,000 financing statements registered on the NCR portal. We have over 600,000 borrowers registered on the NCR portal, and out of that 600,000, almost 300,000 are linked to female borrowers. We have about more than 1 million movable assets pledged. So I will be talking about the benefits of STMA for MSMEs. So the STMA allows the borrower to demonstrate their credit worthiness by showing how he or she has been handling previous loans. Also, we have pledge collateral can be in the pledge collateral can be in the possession of the borrower. So what this means is that if you collect a loan from a financial institution as a borrower, the financial institution does not have to collect your collateral. If, to say, you're a Bolt driver and they collect the car, there's no way you'll be able to pay the loan. So the collateral is going to be with you so that you can make money and pay back the loan. Also, one of the benefits we have, the STMA guarantees that the movable assets on which the security interest has been created in favor of the creditor can still be in the possession of the grantor for normal use. Also, it permits certain information about the assets pledged as collateral to be made available to the public, thereby assisting the creditor to take a decision about the loan in favor of the borrower. So what this means is that because the NCR is registry based, we have information of all customers on the NCR portal. So when you're trying to take a loan, your details, everything about you is going to be on the NCR portal. So now we're going to talk about the risk mitigants. What are risk mitigants? Risk mitigants are actions or strategies designed to reduce the potential negative impact of risk. So in this situation, we have about 3 or 4 risk mitigants. I would love to talk about risk of loss of assets. What risk of loss of assets means is that it refers to the potential of an asset to be damaged, destroyed, or stolen, resulting in financial loss for the owner or holder. Also, we'll give a 10-day default notice before repossession and additional 10 days before sale of collateral. What this means is that before the creditors can repossess, they have to give a 10-day notice to the creditor has to give a 10-day notice to the borrower. And also, borrower can repay loan before expiration of 10 days or redeem the collateral before sale. We also have identity risk. What we mean by identity risk is that it refers to the potential for unauthorized access, misuse, or compromise of digital identities. Financing statements, assets. What risk of loss of assets means is that it refers to the potential of an asset to be damaged, destroyed, or stolen, resulting in financial loss for the owner or holder. Also, we'll give a 10-day default notice before repossession and additional 10 days before sale of collateral. What this means is that before the creditors can repossess, they have to give a 10-day notice to the creditor has to give a 10-day notice to the borrower. And also, borrower can repay loan before expiration of 10 days or redeem the collateral before sale. We also have identity risk. What we mean by identity risk is that it refers to the potential for unauthorized access, misuse, or compromise of digital identities. Financing statement is inactive if there is an error in the unique identification number of the grantor or the serial number of the collateral. This protects grantor from attribution from wrong identity, protects grantor from creditor repossession of assets. And also, we also have operational risk. What this means is that financial statement is renewable or extendable. Financing statement can be amended. So after a financing statement has been perfected, it means that you can still come back and amend the financing statement. If as a borrower you want more loan, if you want more loan, you can also come back and You can also come back and amend your financing statements. So we also have legal risk. Legal risk refers to the potential for financial or other losses stemming from non-compliance with laws, regulations, contractual obligations, or from the legal consequences of actions or inactions. What this is trying to say is that there will be lawsuits. There are going to be lawsuits in terms of there's going to be a lawsuit in recovery. What we're trying to talk about here is how the creditor would repossess. The creditor should issue a warning notice 10 days before repossession. Also, it must be stated in the security agreement whether parties will submit to the court of law or not if a follower defaults. The creditor shall, within 15 days of the disposal of the collateral, render a statement of account in writing to the borrower, the grantor, and any other creditor with a security interest in the asset. The statement of account will state amount realized from the disposal of the collateral, amount of the cost of disposal of the collateral, balance due to the grantor or other creditor. So also for peaceful recovery, we have the police, which also plays the enforcer role. They assist in peaceable repossession of movable collateral by creditor where there is a court order. And also we have the court of law. The court of law interprets the STMA law, grants order for repossession of movable assets. So now we're going to talk about the parties that lend against STMA. So parties that lend against STMA in this situation, we have the commercial banks, microfinance bank, and developmental financial institutions. So commercial banks like Zenith Bank, GT Bank, your commercial banks, they lend against movable assets. And also microfinance banks also lend against movable assets. So what we're trying to say is that these institutions should be able to give you a loan using your movable assets by pledging your movable assets. Thank you very much. And also you can always contact the NCR via our website is here, www.ncr.gov.ng. On Facebook is collateralregistry.ng. On X is collateralregistry.ng. YouTube National Collateral Registry. Our phone numbers are also down. You can always reach us anytime, anywhere for any unresolved problems. Thank you very much.